Hanna Buxbaum, Interim Dean of the Law School. I'm delighted to welcome you to this lecture by Professor Harold Koh, this year's holder of the George P. Smith Visiting Distinguished Chair. The Smith Chairship was established in order to support visits to our school by distinguished scholars and practitioners of international law. Its benefactor, George P. Smith II, is a 1964 graduate of our school and a professor of law at Catholic University in Washington, D.C. He is himself a distinguished scholar of domestic and international law and a true pioneer in the interdisciplinary study of law, science, and medicine. We are fortunate to have him with us today, and I hope you will join me in thanking him for his generosity in creating this. Today, we are honored to host Professor Harold Hongju Koh as our Smith Lecturer. With all of the public speakers here at the school, a full introduction of credentials and background takes a good amount of time. In Professor Koh's case, even touching on the highlights of his career would eliminate half of his speaking time, and I am reluctant to do that. So let me say simply that he is our nation's preeminent international lawyer. His academic career is one of tremendous distinction. Professor Koh joined the faculty at Yale Law School in 1985, served as the school's dean from 2004 to 2009, and is now the Sterling Professor of International Law there. He is a leading expert in public and private international law, national security law, and human rights. His contributions have been recognized with honorary degrees from more than a dozen universities and countless awards, including awards from Columbia Law School and the American Bar Association for his lifetime achievements in international law. Professor Koh has also engaged in significant service to our government. Before joining the faculty at Yale, he served as attorney advisor in the Justice Department's Office of Legal Counsel. Later, he served as Assistant Secretary of State for Democracy, Human Rights, and Labor. And from 2009 until earlier this year, he was legal advisor to the Secretary of State, responsible for providing legal advice supporting the State Department's formulation and implementation of foreign policy. For his service in that capacity, Hillary Rodham Clinton honored him with the Secretary of State's Distinguished Service Award. To students who are thinking about the critical importance of international law in shaping our global and domestic environment, or thinking about how international lawyers can contribute to bettering that environment, I would say study Harold Koh. His lecture today is entitled Turning the Page After September 11. Please join me in welcoming Professor Koh.
Thank you, Dean Buxbaum. And she did not mention that we are, in fact, co-authors of a case book on transnational business problems. And it's been a great joy to be here in the land of the Hoosier and breaking away. I wanted to pay special tribute. Whoa. Excuse me. The technical assistant here, if you're available, I'd appreciate your help. I'm particularly happy, it doesn't work there, to honor George Smith, who is the distinguished alum of this university. It works now? Great.
I can't test it without making it work. So.
Good, go ahead.
Okay.
I'll tell you when to do the next one. Oh, it works. Technology. As you can tell, he's a distinguished professor at Catholic University, a world traveler, great expert on bioethics, and a generous benefactor of this law school. He's particularly well known in Australia and New Zealand, where I spent much of the summer, and a good friend of several friends of mine, including Michael Kirby, of formerly the Australian Supreme Court. And it's a great tribute to him that this series has attracted such a wonderful set of speakers, and I'm honored to follow in their line. As Hannah told you, I spent my last 30 years, I think I'm going to move out here if you don't mind, 30 years as an international law professor and scholar, 5 years as a dean, about 20 years now as a human rights lawyer, and 10 years in the US government. They don't all add up to my age. Some of them overlap. My last 4 years, here are some visual proof of my activities. Upper left-hand corner representing the United States at the UN Human Rights Council. Here in the bottom left, taking a helicopter flight to an undisclosed military location. Bottom right, Guantanamo. I first went to Guantanamo in 1991, and I've been there now 19 times. And then upper right hand in Moscow for the president's first summit with Putin. On the left, going to Afghanistan, in front of the Parthenon during the Greek financial crisis with former Secretary Albright, on our way to the funeral of Nobel Prize winner President Kim Dae-jung. And I've appeared in many courts representing the United States at the International Court of Justice in the Kosovo case, at the European Court of Human Rights, the African Court of Human People's Rights in Arusha, and have been the head of our delegation to the International Criminal Court in The Hague. This is probably the most famous picture of me. After the fall of Gaddafi, we were in Malta, which is a small island off the coast of Italy, and they gave Hillary a transport plane. So everybody else was sitting alongside the walls as when they're jumping out as paratroopers. But they thought it was unworthy, so they put in 2 rows of business class seats, and as the next highest ranking person on the plane, I'm sitting behind her, the press got on, started taking pictures of us. It was a little embarrassing, so we started checking our BlackBerries. And I actually did BlackBerry to her, look over your shoulder. That's what she's reading in this. Now, I worked on many, many issues, too many to count, really. Here's Chen Guangchen, who's the famous blind Chinese activist who we were able to get to New York. They included disasters, natural, like the earthquake in Haiti, the meltdown of the Fukushima power plant in response to a earthquake and tsunami, WikiLeaks, which was a man-made natural disaster, took a huge amount of time, Arab awakening, human rights issues around the world, international criminal law, cyberspace, issues of private international law in the world economy, public health, the environment. But far and away the most challenging issues, and the ones I've been asked the most about, concern the fallout of September 11th, which is now 12 years ago. And I think it's fair to say that thinking about it has consumed a lot of my time. Now, for those of you who haven't worked in the government, there are 4 things I just wanted to flag about differences between being in the government and being a professor. By the way, here's my brother, Howard. He's the Assistant Secretary for Health and Human Services. My mother loves this picture of us because it looks like Obama works for us. But what we learned is, number one, you're not the only lawyer. When you're a professor, you just say what you want. You don't check with anybody. When you have a client like Hillary Clinton and Barack Obama, who are outstanding lawyers, they actually have their own views. And I know it's hard to believe, but if you want to do X and they want to do Y, if what they want to do is lawful, that's what you do. Because after all, you're not your own client. You're also not the only lawyer. There were 200 lawyers in my office. The Justice Department had 10,000 lawyers. The Defense Department had how many lawyers? Any guesses? Just give me a guess. We had 200. 17,000 lawyers. Government has been given steroids, while all other parts of the government have been choked of budget, and it's led to a tremendous skewing. You also have the lawyers in the intelligence agencies, Homeland Security, on issues of economic sanctions, Treasury, the Commerce Department, the National Security Council, legal office. To take a position for the US government requires the concurrence of hundreds of individuals. If I was giving a speech like this for the US government, it would be edited by well over 100 individuals. Anything that was not clear by everybody, I couldn't say. Some of the speeches that I gave that got the most attention were being edited while I was delivering the speech. In fact, they would hand up notes suggesting edits to stuff that I hadn't gotten to yet. And while you're giving the speech, you're supposed to read it. And one thing that, again, is surprising to many academics is you operate within a system of precedent. Walter Dellinger, my friend who worked at the Office of Legal Counsel, pointed out that when he was working on questions of constitutional law at the Office of Legal Counsel, people didn't care what he had written about it. They cared what the Office of Legal Counsel had written about it. And I was often asked about this. And it was usually in this form. I've just read a footnote in an article you wrote when you were coming up for tenure when you're 27, and I've just read an opinion from your office. Aren't they contradictory? Haven't I got you? Well, the answer was usually no. In fact, there's always no. But secondly, why would you trust me more when I'm writing a footnote that has no consequence and don't know anything, as opposed to 30 years later when people's lives depend on it and hundreds of people have debated about the subject? I just never understood this. And when we're working within a system of precedent. Now, that doesn't mean you can't change the precedent, but there's a rule of stare decisis, so you have to work to change the precedent. And most fundamentally, you have to play the hand you're dealt. There's a story told about two guys from Galway. One of them says, how do I get to Dublin? The other guy goes, I wouldn't start from here. Well, I know the feeling. Would you like to actually, everybody wants to start at a time of peace and prosperity, as opposed to 3 wars, the worst financial meltdown, toxic political environment, but you don't get to choose. In fact, you're lucky if you get it at all. And so you have many, many roles to play. In particular, I played a number of roles as managing partner of the General Counsel's office. I was a counselor to the senior leadership of the State Department. So we did what general counsels do. You know, we buy buildings. They happen to be in Kabul. We get visas for people. They happen to be in Iraq. We manage conflicts among different parts of a very large and complex organization. But a unique role of the legal advisor of the State Department is to be the spokesperson and conscience of the US government with regard to international law. I felt it was my duty to explain our legal positions and to defend them, because after all, as Tony Stark says in Iron Man, I don't have anybody but you. You know, if I wasn't ready to defend the US government's legal positions, I shouldn't have taken the job. Which I think often puts you in an interesting position. I feel that through my life I've had the exact same commitments, but I've played different roles. I've described them. I consider myself a man of peace, a professor of international law, a defender of human rights, and for 4 years I was a lawyer for a nation at war. Now, it comes up because sometimes as part of this gotcha, people will say, you know, you came to Indiana and you condemned torture, and now you talk about the legality of drones. Aren't you a hypocrite? To which my answer is no. Because all torture is illegal. As I said in a speech I gave here a number of years ago, the president cannot be torturer-in-chief. But if you believe in laws of war, some killing may be regrettable, but killing in wartime is lawful if you follow the laws of war. And it is the inescapable duty of a government lawyer to police the line between lawful and unlawful killing, and also uses of force that do or do not, in your judgment, serve human rights. It's a difficult decision, it's an agonizing decision, but it's part of your job. Now, I say this because this is now 12 years since September 11th. Wednesday was. Even to look at the picture is just to remind you how shocking it was and how much we've forgotten. It was a grotesque human rights violation. More than 3,000 people of many nationalities were killed. It launched a novel kind of war with a non-state actor, Al-Qaeda, a transnational non-state actor. People debate about whether it's a war. I became more and more involved. So one of the great ironies of my life, as a professor, I know the names of all my students. As legal advisor of the State Department, I knew the name of every Al-Qaeda leader. I knew their resume. They're the same age as my students. One guy was born on the same day as my own daughter. And on the day that she turned 18, I remember what she did on the day he turned 18, the exact same day he killed somebody. The day she turned 21, I remember what she did. On the day he turned 21, same day he started to lead a cell, planned suicide attacks. And it gives you a long pause about exactly what is involved in that would turn some people's lives in such a desperate direction. Now, it's very clear that this kind of human rights violation and war demanded a strong response, but that was nevertheless respectful of human rights. You could call it just security, a focus on security, but also a focus on justice, not just security. But the question, really, and we're asking this 12 years later, is the 9/11 era a phase, which we hope is coming to an end, or does it constitute the new normal, which will last forever? And my hope is it is a phase, and that the end of that phase is signaled by a speech the president gave in May, but which I don't think got the attention that it deserved. Now, interestingly, 9/11, also the fall of the Twin Towers, after the fall of the Berlin Wall, very clearly signaled the beginning of a post-Cold War era. It showed that globalization, or what Tom Friedman calls the world is flat, has both positive elements but also great dangers. A person with a laptop can work tremendous harm now in a way that was just impossible years ago. And unfortunately, it comes at a time where we have an absolutely toxic U.S. domestic political environment, virtually incapable of dealing with any issue, no matter how simple, saving our credit rating or passing a budget, without turning it into a partisan and destructive fight. Now, I was thrilled to be invited back because this will complete what I will call my Bloomington trilogy. In 1998, I gave a speech here at the Harrison Lecture called How is International Human Rights Law Enforced? In 2005, at the kind invitation of my dear friend Don Johnson, I spoke at her conference and gave a speech called Can the President be Torturer in Chief? What I want to do today is talk about, can we turn the page after September 11th, after 12 years, how to turn the page, and if so, what should be our guiding principles going forward? Now, this is really two questions. First, the big picture question, do we have an overarching strategy to adapt 20th century international law to solve 21st century problems? And second, how would application of this broad strategy in the counterterrorism realm let us turn the page on September 11th? So that's what I propose to discuss. Now, notice I mentioned 20th century law, 21st century problems. If there's one thing that dawned on me my first day as legal advisor, it was this. Someone came into my office and said, guess what? The frozen embryo of a panda, which is owned by a large Asian nation, is being stopped at the border. The question is, can it be attached through prejudgment attachment, or is it covered by the Foreign Sovereign Immunities Act? the Foreign Sovereign Immunities Act of 1976, the framers had never contemplated this issue. And since this happened repeatedly, it became clearer and clearer to me that most of our treaties, international treaties, the foundational ones were adopted in the wake of World War II, that most of our laws on US national security were in the wake of Vietnam and Watergate. That's more than 40 years ago. Our lawmaking processes have virtually broken down since then. It's very hard, almost impossible to get a 2/3 vote for a new treaty. Congress has pretty much gotten out of the business of legislation, or thoughtful legislation anyway. So we have 21st century problems in 20th century law. And the question is, what do you do about it if you want to be faithful to the law? And here is my argument. There are two broad approaches you can take. One approach is what I call the Tina Turner approach. What's law got to do with it? What's law but a sweet old-fashioned notion? You know? We're in a black hole. Nobody thought about this, so there must be no law to apply and we can do whatever we want. This, I think, was the fundamental failure of the Bush administration, was to treat new problems as black holes and to say that they are not subject to legal analysis. The Geneva Conventions, for example, are quaint. Why? Because the Geneva Conventions didn't exactly think about al-Qaeda detainees on Guantanamo. What's the alternative approach? I would call it the spirit of the laws, or as Montesquieu put it, translation. Okay, so the rules that we have don't cover this exact situation, but they address the general idea, and we should go and try to make a good faith effort to translate the spirit of the laws from one setting to another. So those of you who say, you know, Obama and Bush are exactly alike, both of them violate the law, I would say, I think there's a philosophical difference. It's a black hole approach versus a translation or spirit of laws approach, and that is all the difference in the world if you are committed to the rule of law. Now, let me answer these questions. Do you have an overarching strategy, and how does it apply? Answer them both yes. And with a very simple concept. The driving strategy can be stated in 5 words. Smart power. Engage, translate, and leverage. What does that mean? International law is a form of smart power. We should engage around our values. We should not apply black holes. We should apply the spirit of laws from 20th century to 21st century problems. And we should use the legal rule as a foundation to be blended with other tools to produce policy, including diplomacy, development, technology, markets, international institutions, and military force. Now notice, what it's not saying is that we abandon the use of military force, but that we limit it to those things that you can only address through that means and lawfully. And it means that, therefore, our soft power is the framing element of the package. Now, why would this be a good approach? Those of you who have read Paul Kennedy's Decline and Fall of the Great Powers know the basic thesis is that great powers have lost their dominant position because they try to control the world with hard power. It's extremely expensive. They get into imperial overstretch. They get grossly indebted. They get tired of war. Sound familiar? And then at a certain point, they lose their position. So how can the United States lead at a time of financial crisis, crushing debt? And the answer must be to try to use our moral standing to create a system of smart power in which the United States continues to mobilize support by engaging around values. And I would argue that that is the driving theme of what the administration has tried to accomplish, even if they have failed significantly in a number of areas. And one of the most interesting areas is the recent crisis in Syria, about which I'll say more at the end of this lecture. But I would argue that this is the strategy. And I would argue that this is the right strategy. And I will argue that it is a strategy that whoever is president, the United States will need to follow. And in contrast to the last administration, I think they tended to use a unilateralist approach rather than engagement, a black hole approach, not translation, going it alone, not leverage. So this is a significant philosophical difference. Now, where did this begin? Look at the young Barack Obama boy, how young he looks, 2004, 2008. He calls for a new era of engagement, respecting the law, living our values. Doesn't make us weaker, it makes us safer, it makes us stronger. And then my boss, Secretary Clinton, said American foreign policy should use smart power, the full range of tools at our disposal, including respect for law and human rights. Now, at the time, people thought this was just a slogan, Hillary's slogan. But if you go to Google and put in Hillary Clinton and smart power, you will see dozens of speeches that she gave over the course of her time. Smart power and global women's issues, smart power and 21st century economic statecraft, smart power and cyberspace. It's a comprehensive strategy in which diplomacy is important, which means that the Secretary of State has an important leadership role to play. Now, let me illustrate this in a number of different areas. I have dozens and dozens of examples. I'm just sparing you, but I'm happy to talk about any of them during the break, Q&A. But I want to lead to 21st century war. Because the best way to think about 21st century war is a set of problems nobody envisioned. Cyber war, private security contractors, the use of drones, humanitarian intervention. But let's get there by starting simple. Human rights. How do you address the issue of LGBT rights? Hillary Clinton had a choice. She could not address it. That's not engagement. Or she could take the opposite approach. She went to the UN Human Rights Council to address this on Human Rights Day. Now, by the way, why was this not previously possible? We had not engaged with the Human Rights Council. We had boycotted them. She chose that as a forum to engage. Translate. LGBT rights are human rights, she said. What she did was simply to expand the concept of human rights to include LGBT rights. She translated the idea of LGBT rights into the concept of human rights. Why did she do this? Because 15 years before in Beijing, she had done the exact same thing when she said women's rights are human rights. In other words, the apparatus of human rights protects these people's rights too. And if this is a place, the Council committed to the protection of human rights, you need to protect LGBT rights. And leverage, to combine this initiative with such domestic initiatives as Don't Ask, Don't Tell, same-sex benefits, marriage equality, the DOMA movement, which led to Supreme Court litigation backed by the Obama administration in Windsor and Perry, have led to a sea change on this issue in this administration. Or what about international criminal justice? The United States has had a very rocky road on this, as you all know. The United States prosecuted the first cases at Nuremberg and Tokyo. But from the start of the International Criminal Court, we had a schizophrenic view, which is, on the one hand, we supported all ad hoc tribunals, the Yugoslav, Rwanda, Sierra Leone, Cambodia, Lebanon Tribunal, but we were opposed to the International Criminal Court. The official position of the last administration was to hope that the court dies, even though 110 members had joined the court. And we have laws. We're not going to ratify the Rome Statute anytime soon. If you took a vote now, you'd probably get 30 votes in the Senate. We also we have a law called the American Service Members Protection Act, which limits the US government's capacity to support the court financially. So when I became assistant legal advisor, head of these delegations, we had a long meeting and I said, our approach is going to be this. We will turn the policy around 180 degrees without changing any laws. The analogy is to turn a car around inside a garage without opening the garage door. I did this once with my son. It's not easy. It takes a long time. To align our policies of support to the ICC and the ad hoc tribunals, we engaged at The Hague, in New York, in Kampala. We don't made quite explicit that we do not oppose the object and purpose of the Rome Statute. We supported unanimous referral of the Libyan case, and now all pending prosecutions before the court. So the position has been turned around entirely without a change of law. But nevertheless, everywhere I go, people say, well, why hasn't the US ratified the Rome Statute? Not seeing that the difference in policy is the precursor to that important step. Engage, translate, and leverage. Let's take another example. Global warming and the Arctic. Consider this. People use fossil fuels. Fossil fuels make the atmosphere warmer. The ice cap melts. You can sail deeper into the ice cap. You can look down. You see land that can be drilled by a coalition of the drilling. And you can extract more fossil fuels if that is what is allowed. So the real question is, if we want to seek a governance structure, how do we do it? At Copenhagen, Secretary Clinton and President Obama personally went and in the last days got a politically binding but not legally binding agreement for a global temperature goal. At Durban, 2 years later, the outcome document said we would move to an agreed outcome with legal force. Don't you love that? One of the lawyers in my office went for it, offered that at 3 o'clock in the morning. Legally binding, they wouldn't take an agreed outcome with legal force. They said, okay. Don't you love lawyers? And then we leverage this basic legal argument into kind of a layer cake, layered cooperation, a governance regime centered in a new institution called the Arctic Council, with a bunch of non-legal understanding on top of a framework of the law of the sea. Now, there's an amazing thing, which is people who want to protect our sovereignty are opposed to our joining the Law of the Sea Convention, even though the net result of, by the way, one of the heroes of this is Dick Lugar, your senator, who has taken the opposite position, although, as I've noticed, you're not exactly a seacoast state. Those people who are protecting our sovereignty are surrendering the Arctic to the Russians and the South China Sea to the Chinese, who are the people they're most worried about, and they're doing it in the name of sovereignty. George Smith is here. He's a great expert on bioethics, so let me give you this example. Suppose a lesbian couple lives in a foreign country, and the American mother has implanted in her an in vitro child who is the product of neither an American egg or an American sperm. And the baby is delivered 9 months later through her birth canal. Is that baby an American citizen? That baby has been carried to term for 9 months by an American mother. Under US immigration laws, there's a requirement of a natural relationship between the mother and child. And the US law has been consistently construed as a genetic relationship, a DNA relationship. I had the temerity to suggest that natural relationship could include genetic or gestational. I thought this is a reasonable effort to apply the spirit of the laws. Now, there's been a continuing battle about this issue in the US government. We could talk more about it. But what it's really done is made me think a lot more about what will be a subject of my future inquiry, the human rights of clones. I mean, there are clones soon among us. Can they be harvested? Can they be made lesser persons? Do they have human rights? Are they born human in terms of the human rights framework? Can we translate clones into the existing human rights framework as Secretary Clinton has done? Who has rights in cloning? Do outsiders have a right to claim a right and block cloning? All of these questions have been pretty much unexamined. What about cyberspace? And think about 4 different faces of cyberspace: internet freedom, intellectual property, and piracy, e-commerce, and cyber war. The Universal Declaration of Human Rights remarkably speaks in terms of the right to seek, receive, and impart information and ideas through any media and regardless of frontiers. It's almost speaking prophetically about the existence of cyberspace. And what we tried to do in Secretary Clinton's time is to set out some framing principles in each of these areas and start a process of what we would call engage, translate, and leverage. In particular, on cyber conflict, there are some countries that have a black hole approach, particularly China and to some extent Russia. We put forward the proposition that cyberspace is a world governed by the laws of war and international law. We engaged in two forums, the group of governmental experts at the UN and the World Conference on International Telecommunications, with an effort to translate the laws of war to declare that cyberspace is not a law-free zone, and we've tried to leverage this into a series of governmental and private standard-setting exercises. Or how about private security contractors? Most of the people who are soldiers these days are not government employees. They work for groups like Blackwater and others. Those people are essentially ungoverned. How to make sure that they obey the Geneva Conventions. Again, engage. The Montreux document, a set of binding, a non-binding set of principles and practices governing private actors, translate into a code of conduct that more than 500 countries have now subscribed to, and lever through private contracts to internalize norms into contractor behavior. This is an example of what I call transnational legal process. This brings me to 12 years ago. Suppose that Al Gore were president, and suppose that 7 days after, when Congress voted an authorization of use of military force against al-Qaeda, he went on TV and he said the following: 3,000 people were killed on September 11th. It's a gross human rights violation. We need to protect our country. We've identified the culprits who we believe to be al-Qaeda. We're going to devote ourselves to a battle to protect ourselves against them. I intend to conduct that conflict consistent with domestic law and the laws of war, but it is a conflict we must have. Let me tell you what I will not do and what I will do. I will not invade Iraq. I will not torture anybody. I will not open Guantanamo. I will not do extraordinary renditions. This has nothing to do with our core mission. Let me tell you what I will do. I will mobilize a smart power strategy in which we try to isolate al-Qaeda, engage with Afghanistan and Pakistan. We will try to convince the people of those regions not to pursue terrorist attacks on US soil. But there will be a group of people we will not be able to convince, and those people include Osama bin Laden and senior leaders. And I will use every technological means at my disposal to target them and them only, to either capture them or remove them from the battlefield. I will consult with Congress. I'll do this transparently. I hope we're done quickly so this war with al-Qaeda will end. God bless us, and please stand with us in the years to come. Now, if he had said this, my guess is most Americans would say, we agree. We support you. We don't like it, but we don't really see an alternative. So what happened instead? Everything that shouldn't have been done was done, a stunning diversion of resources. Al-Qaeda dispersed, and now, ironically, it is the exact thing that he proposed to do, or should have proposed to do at the time, which is the use of precision targeting of senior al-Qaeda leaders that has become the subject of greatest controversy for the Obama administration. I say this for a simple reason. Drones are a tool. They are not a strategy. They're part of a much broader approach to ending the war with al-Qaeda. It requires us to engage with our allies, to translate legal rules to new settings, to apply lawful targeting and detention rules, to combine limited use of force with other tools. So people are obsessed with drones, even though that technology is already outmoded. Does anybody believe that in 10 years, if someone fires a drone, it won't be taken down with a cyber command? This is like being upset about catapults. And let me posit this basic proposition. I do not believe drones are per se illegal. If they're legal or not depends on how they're used. They can be used illegally, obviously. By their nature, they can be more discriminate. Many people who don't object to the use of who don't object to the use of the atomic bomb, which is inherently indiscriminate, have raised huge fuss about the use of drones. So the question in my mind is, what rules should govern drones? Now, Hillary Clinton a year ago specified a smart power approach, long-term use force for limited and defined purposes within a broader non-violent frame, deploy diplomacy, development, education, people-to-people outreach, challenge al-Qaeda's ideology, counter its propaganda, and diminish its appeal. And she said, with regard to a certain hardcore group, the only thing you can do is persistent and precise use of force to degrade al-Qaeda. And this is all happening in the context of Arab Spring. When Arab Spring broke out, I was sitting with Secretary Clinton, and she said to me, there is one bright spot. And I said, what's that? And she said, they don't want to join al-Qaeda. They want to govern their own country. And the question is, can we keep them on that path? Up until now, they've had no other avenue. Can we get them to move away from repression to embracing universal human rights, discredit extremism? And here's the whole set of countries on which I worked. And I can tell you it's been a gigantic and difficult challenge. Now, in May, President Obama, I think, embraced this paradigm directly. He said, we have to define the nature of the struggle that will define us. He said, and most fundamentally, there is no global perpetual war on terror. The Obama administration has never, ever used that phrase. We don't believe there's a global war on terror. But we do believe there's an armed conflict with al-Qaeda, which is about 3,000 people, with about 60 leaders. And he said, the forever war must end. We must repeal and replace and not expand the authorization of use of military force. Comparing the differences, this administration has never said it's a global war on terror. They have not applied a black hole approach. You never hear claims about inhumane treatment. And perhaps most fundamentally, they have relied on a fact-based approach, which means if they think someone is a significant, continuing imminent threat, they use a law of war approach against them. But it turns on who they have done. That case needs to be built. Now, there are 4 issues going forward: transparency, consultation, standard setting, and ending the war. I will just simply sketch that these are possible. But contrast this again with a different approach that was applied for 8 years after 9/11. Transparency, I think frankly on this, the Obama administration was very slow, and consultation. But they have now started to move in this direction. Better late than never. And most important, institutionalizing standards and now trying to multilateralize those standards with our allies. Ending the war, making it clear that we're not at war with everyone who hates America, we're not at war with propagandists, and we're not at war with self-radicalizers. 12 years after September 11th, every terrorist group sympathizes with al-Qaeda, but that doesn't mean they're part of al-Qaeda. Every Beatles imitator band is not part of the Beatles, let me put it that way. And this is combined now with smart power approaches to Iraq and Afghanistan, declining military engagement, continued civilian engagement, developing civil and society, and enhanced diplomatic engagement. What about closing Guantanamo? A great failure of this administration. It is possible. It just needs political will. And if the perpetual war ends, the legal authority to hold disappears. So here are some important steps, important people in charge: implementing previously designed plans, transferring large groups who are cleared for transfer, that's 29 people, negotiating on block transfers for Yemenis on Guantanamo, that's another 80, trying in civilian courts and on US soil those who are suited for trial, and begin review of those detainees to see who can be safely released. Which brings me to the final dilemma of 21st century war: humanitarian intervention. Libya, which I talked about yesterday at the Center for Constitutional Democracy, involves force, but it was part of a smart power approach. Now, some people think Libya was a failure. I think it's better than it was. It involved a no-fly zone, an arms embargo, assets freeze, diplomacy, a travel ban, an ICC referral with the goal of protecting civilians, because Gaddafi had forfeited his responsibility to his own people, and it was done on a multilateral basis with 2 UN Security Council resolutions. This, by the way, is a picture. I went to Tripoli University, the same flight that I took with Secretary Clinton. In the university, which had been previously called Gaddafi University, there are gallows, and students who had protested against the government used to be hung from those gallows. And the students went to class with bodies hanging there. So people who say it's worse now, that's not happening now. Instead, you have these cartoons making fun of Gaddafi, which are all over the place. And that leads us to today's problem, Syria. How to combine diplomatic strategy. The meeting's going on in Geneva today between Kerry, Lavrov, and Brahimi, with various kinds of multilateral discussions, including with the Syrian opposition, with lawful smart power. Now, the original objectives were to secure chemical weapons, achieve ceasefire, oust Assad, give humanitarian aid, and secure accountability. And the problem we faced consistently was the Russian and Chinese veto, 4 vetoes. And we've had, really, for 3 years, an all soft power approach. And then after August 21st, threatening the use of a military strike, which the president argued was necessary because of a clear and deliberate military use of, offensive use of chemical weapons. I have no doubt of the facts of this from everything I know. The danger, of course, was it would have been challenged under both domestic and international law, and this approach, which he suggested, would have shifted the issue from Assad's conduct to our conduct and called into question the president's engagement to the very values of this strategy: engagement, soft power, and ending a war. In fact, in his speech last Tuesday, that's what he acknowledged. And ironically, it would have put him back doing exactly the things he criticized: unilateralism, black hole, and going it alone. And perhaps most sickening to me, it would have let Putin play the soft power international law card. Here is his New York Times op-ed. We're not protecting the Syrian government, we protect international law. We don't want to throw the system of international law and order out of balance. Stop using the language of force, return to soft power. This from the man who vetoed 4 consecutive resolutions that licensed the slaughter of hundreds of thousands of people. And in the same op-ed he says, and guess what? Chemical weapons have been used by the Syrian opposition, but not by Assad. So obviously any strategy that allows him to take a moral high ground is flawed. But what's happened? Interestingly, while we've been watching over the last couple of weeks, we've stumbled back in the right direction. The administration's position has mutated back to engage, that's what's going on, translate, and lever. And I do believe that inserting the threat of hard power into the mix has motivated a diplomatic process. The goal of the hard power is simply to secure control of the chemical weapons, which is only one piece of the big picture. Properly handled, I think Syria can be addressed within the broader post-9/11 strategy. In closing, can we develop a broader strategy? Can we turn the page? Can we enforce human rights while dimming memories of the human rights debates of the past? I think the answer is all 3. More fundamentally, can I finish my Bloomington trilogy? I certainly hope so. And guess what? Finally, Hugo Grotius had a very interesting time as an international lawyer, but he did not deal with anything like this. International lawyering in the 21st century, and particularly a strategy of international law as smart power, is my view the way to do 21st century international lawyering. That's why I returned to teaching. That's the exciting task at which you're all engaged. It means engaging, translating, and leveraging law. After all, it is the creation and promotion of legal institutions that marks an advance of civilization, so that we don't always have to use hard power as the solution to all problems. We are architects, not scriveners, of a new world order, and that's what I welcome all of you as part of this important joint exercise. I've gone on for a while, but that is essentially what I want to say. Thank you.
There will be a reception up on the third floor in the faculty lounge, to which you are all warmly invited, but I think we do have some time now for questions in the public forum for those of you who would like to ask them.
Yes.
Yes, Professor Koh, for many of us who worked for President Obama and who share the basic framework that you outlined, there remains a troubling question, and I can really ask it in two parts. One is, to what extent have some of the applications actually not met the standard? And let me cite, for example, the assassination by drone strike of Anwar al-Awlaki's 16-year-old son. And more broadly, don't we, in the name of being the indispensable nation, isn't there a risk that the Obama administration continues to practice a double standard? For example, on weapons of mass destruction, where Syria is certainly in a reprehensible position, but it's by no means the only country, nor is Iran, outside certain conventions. I mean, if you take the CWC, the BWC, and the NPT, some very close U.S. allies, including Israel, are outside those conventions. So if we truly, and we practice offensive cyber war, as the Snowden revelations have shown, isn't there a danger that unless we truly internationalize these standards in a way that we would be content to have emerging powers practice back to us, that they will fall apart and will be back in the black hole?
Oh, on the last point, I completely agree. We must internationalize these standards. Have there been failures of the application of these standards? Of course. No human institution is perfect. Was the killing of Awlaki's 16-year-old son a mistake? Yes. But there is what people are trying to do, and then the mistakes they make as a part of it. And I think the problem that I often face in academia is, what is the right strategy? Are we pursuing it? And sometimes it doesn't work, or sometimes you make a mistake. But let's not distinguish, or let's not confuse the right strategy with the wrong strategy, or confuse the mistake with the issue. So and then we end up in the situation when we can't do anything, when we can't do the right thing now, let's not do anything. So Syria is using chemical weapons. They're not the only ones. Obviously, a lot of people have weapons of mass destruction. Syria is using chemical weapons on its own people, deliberately have done so over the course of the last number of months. This is something that has not been done since early 1980 in Halabja. And it's deliberate. It came from senior leadership. It targeted children. There's no indication they're going to stop doing it. So let's not say that many, many people have weapons of mass destruction and we can't do anything about any of them. And I ask you this, to those who say it's illegal, are you really saying to me that a Russian veto, a consistent veto, means that if tomorrow we knew Assad was going to gas and kill 1 million children, we just simply stand by and watch that in the name of international law? That's, of course, Putin's position. I'm not sure we need to create that position. And if the concern is about creating an exception, isn't the job of lawyers to create an exception with limitations so that the exception doesn't become the rule? Isn't that what judges do every single day? In the government, as opposed to in academia, it's easy to criticize, and I did, and I do, and I will. And I don't have to apologize for Obama. He hasn't been a perfect president. And on the other hand, I urge all of you, when there's something you don't like, to ask this question: what should we do instead that's better? If you don't have a good answer to that, you haven't thought the problem through enough. So let me go back to another example. Anwar al-Awlaki. Anwar al-Awlaki, at the moment he died, was more dangerous than Osama bin Laden. He had engaged in countless planning of attacks on the United States. He consulted with Abdul Muttalib with regard to the underwear bombs that got on planes that got over the United States. He instructed Abdul Muttalib to explode those bombs on US civilian aircraft over US soil. He's not a propagandist. He's a killer. And he's also that's his job. That's all he did. Now, he's an American citizen. That should be factored into how you deal with him in the context of war, but it does not immunize him from the tools of war any more than it immunized the general in Japan who launched Pearl Harbor. The United States declared war, pursued that person in the context of a lawful war, identified him as leading combatant, and he was targeted and he was killed. Is it a happy thing? No. Was it lawful? Yes. Did it save lives? In my judgment, it probably did. We have no right to go after his child, and if you do so, you should pay compensation, confess error, or whatever. But again, I do believe, people believe that Obama is rushing to do something in Syria. The real question in Syria is why have so little been done till now? Thousands and thousands of people are dead there. People who went through Rwanda said, we're never going to do this again. And it is very clear, I mean, to this minute, Obama doesn't want to use military force. He's hit pause twice in the last week. So I honestly believe that this is a subject for which, and by the way, I think the administration has done a terrible job on communicating of these issues. Terrible. Because you can't simply announce that this is a huge priority and having not discussed it with the American people for months ahead of time. And you can't suddenly get Congress on board for a vote when you haven't talked to them about what you need to do. For example, it should have been, it seems to me, that the administration gets Congress to agree that if there's an undisputed, unquestioned offensive use of chemical weapons on civilians, the United States will respond with congressional approval. Because people could have agreed to that in the abstract. The number of congressmen I've seen come out and talk about how it's, quote, unacceptable. This is unacceptable, they say. And then, well, what are you going to do? We're going to accept it. Well, that's one reason why Congress is not commander-in-chief, because it's very hard for them. They don't want to make these decisions. There's no happier group of people than Congress right now that they don't have to make this decision. But it doesn't spare us from the difficulties. And the real question is, I think Obama has now at least defined the goal of this action, which is discouraging repeat use of chemical weapons which have not been used offensively against civilians for more than 100 years in a way that makes unambiguous that that's something that won't be tolerated. Now, I think what he has done is to say to the Russians, it's on you. What he didn't do very well was in St. Petersburg, he should have said, I'm going to St. Petersburg, I'm going to talk to Putin, I'm going to say you're protecting slaughter, don't pretend you favor international law. You're a co-conspirator in all this. Don't pretend that you love the UN system. You're blocking action. And if you really believe that this should be stopped, then vote for a resolution that will stop it. The French resolution, which is on the table now, should have been something that Obama talked about when he gave his speech on the Saturday saying he's going to go to Congress. As you know, in that speech, he mentioned only Congress. He didn't mention our allies. But let's not get, I mean, at the end of the day, one of the few accomplishments of international law is to rid the world of the active use of chemical weapons, which I do believe is a per se illegal weapon of war. And I do think steps need to be taken to enforce that restriction according to the law. And I think that the run-up to where we've been has been poor. I don't know what the outcome is. One of the great things about being here today is I have absolutely no idea what's going to happen. But I know how to think about it. I hope that answers your question. Yeah. Yes?
Could you articulate your understanding of the relationship between the commander-in-chief power and Congress's power to declare war? Another way of asking it is, why should we not believe that being commander-in-chief gives the president the power to make all sorts of tactical decisions and decide, how the troops are going to get where they're going and that kind of thing, but was not intended to give the president discretion over it is appropriate to bomb Syria, it is appropriate to inject troops into this situation, but that is an act of war. And the president doesn't get to do that by being commander-in-chief.
So I apologize to those of you who were at my talk yesterday at the Center for Constitutional Democracy, which is entirely about this. I mean, there are three different competing perspectives on this in the academic literature. There's the John Ely approach, expressed in his book War and Responsibility, which says you need prior congressional approval pretty much for every action. At the opposite extreme, there's the John Yoo approach, which is the president never needs any approval for anything. I have a lot of sympathy to John Ely's approach as the original design. I think it's just very hard to argue that this remains the way in which the power is exercised, or that it hasn't been, in the Youngstown way, through consistent interpretation, acquired a gloss. Now, there's a middle ground, which Don Johnson, among others, helped to form during the first Clinton administration, which is articulated best by Walter Dellinger. And what he essentially argues is that when the president can invoke important national interests, undeniably important national interests, and define an operation of a nature, duration, and scope that has limits, that he can initiate warfare without congressional approval, but subject to congressional termination, and also subject to the War Powers Resolution. And I think the president has exercised that authority repeatedly since 1994. Now notice that the Dellinger approach does not allow us to invade Iraq, which is obviously of a nature, duration, and scope that requires prior congressional approval. But interestingly, it also doesn't require the president to get prior approval for hitting command and control of chemical weapons in Syria. It means that the reason he went to Congress to do so is as a political matter, not because it was legally required. So I personally believe that this is actually the way in which the practice has run. I don't believe it's an unworkable middle ground. I think we need legal clarification. If you teach in the con law area, I'm sure you've had lots of discussions of it. I think an additional complication has been added by the fact that you can exercise force without putting boots on the ground, because the political red line for U.S. seems to be putting boots on the ground. But do I think that so John Kerry, who's said many things over the last few weeks, said, I believe absolutely correctly, we're not going to war in Syria. Fine. If he's applying the legal framework I've just suggested, the president has the authority to initiate use of force upon a proper showing of national interest with a nature and duration and scope that maintains at a certain level but doesn't go above that level, and 60 days in, he has to deal with the War Powers Resolution. Now, he then said, I'm talking about unbelievably small. Now, we get to the point where the only use of force you can politically justify is one that's going to do absolutely nothing. That's also very hard to justify. And I think he's backed off of this. He said no boots on the ground, which I think everybody wants to hear. Look where we are now. How are we going to go in, protect inspectors who are removing chemical weapons, and get them to take out an armed conflict? Somebody's going to need to go in there and prevent those people from getting killed. I don't believe it's going to be U.S. soldiers, but it will be UN forces. I mean, by the way, there are a tremendous number of small countries that are unbelievably skilled in this kind of activity. Fiji. Fiji is one of the greatest. These guys they come with these gigantic sticks, And, But as we saw in Srebrenica, where the Dutch peacekeepers were slaughtered, it's not a safe business. And this is where it has to be on Putin and it has to be on Assad, which is you cannot agree to this and not guarantee the safety of the people who go in. And if you don't guarantee their safety, or we think you've done something to them, there will be consequences to you. By the way, I'm from the Richard Holbrooke school. Richard Holbrooke believed that you should have the diplomacy backed by force works better than just diplomacy. Because then people know that the failure of diplomacy has an outcome. It doesn't mean you threaten illegal force, but it does mean that you have a more complicated smart power equation. That's what got people to the table. That's what got us to the Dayton Agreement. And I think that this application and lawful, non-lawful applications and walking this difficult line is the task for all of us who care about both human rights and the rule of law. Final thought. It used to be protecting human rights meant being opposed to the uses of force. But as Nick Kristof has pointed out in the New York Times, being opposed to US participation in Syria essentially guarantees another 100,000 people are going to get slaughtered. So a pro-peace position for the US is a pro-war position with regard to Syria. And it will lead to massive violations of human rights and will send a signal that chemical weapons can be used in that conflict. So that's not a neutral decision. Not to decide is to decide something very definitive about human rights. So the humanitarian intervention debate is how much force preserves the rule of law, preserves security, and protects human rights. The drone discussion is the same. Can these applications be misused or mistakes made? Yes. Is there a much greater risk? Yes. It's the risk between surgery and chemo. Surgery has much higher risk, but it also has a high chance of success. All of which means this is not easy, and that all engaged citizens need to have this kind of conversation as we're having it here in a thoughtful and respectful way. Thank you.